Hi friends, in last few previous classes, we have discussed certain topics of Indian polity. In this class, we will analyze those topics further and move ahead. In this class, we will discuss what is doctrine of separation of powers, doctrine of checks and balances. Now, when we study doctrine of separation of powers, what is doctrine of separation of powers? Early in previous classes, we discussed that functions of a state, functions of a state. What are the functions of a state? That is law making, law implementation, and law adjudication. Now, who makes the law? The legislature makes the law. Legislature makes the law. What forms a legislature? Lok Sabha and Rajya Sabha forms a legislature. Now, who implements this law made by the legislature? The executive implements this law. The executive implements the law made by the legislature. The executives include civil servants. The executive includes civil servants and ministers. The civil servants are called as permanent executives. The reason I have already explained you in the previous lectures, civil servants, IAS, IFS or IRS officers are called as permanent executives because their tenure is fixed. They have a fixed term. Whereas the ministers are part of temporary executives, because they are made ministers only for 5 years. There is no guarantee after those 5 years they will be back into power. So there is no guarantee the ministers will be back into power after the 5 years. So ministers are considered as temporary executives. Now, law adjudication. What is law adjudication? Adjudication means dispute settlements. What is dispute settlements? See, when a legislature makes a law, an executive implements it, two people can have different opinion on certain law. And who deals with concealing this conflict of opinions? The judiciary. So, dispute settlements or adjudication is dealt by judiciary. Now, what relevance it has with doctrine of separation of power? Our topic is doctrine of separation of power. What relevance this law making, law implementation and law adjudication has with the doctrine of separation of power? See, if these are functions of a state, if all these functions of a state, that is law making, law implementation and law adjudication, stays with a single authority or a single authority performs all the three functions, then it will lead to dictatorship or one man rule. See, if law making and law implementation and law adjudication is done by a single person, it will definitely lead to dictatorship or one man rule. So that is not a very apt form of government or governance. So there is a doctrine of separation of powers, that is law making will be done by legislature, law implementation is done by executive and law adjudication is done by judiciary. This is doctrine of separation of power. Now, who gave the philosophy of doctrine of separation of power? The philosophy of doctrine of separation of power was given by a French philosopher called as Montesquieu. The French philosopher Montesquieu gave the theory of doctrine of separation of power. Here I will repeat once again. If the three functions of the state, law making, law implementation and law adjudication, rest with a single organ, that is either legislature, executive or judiciary, then it is called as it will definitely lead to dictatorship. So all the three functions of the state, law making, law implementation and law adjudication, should rest with separate organs, that is called as doctrine of separation of powers. But in case of India, doctrine of separation of power is not possible. In case of India, doctrine of separation of power is not clearly possible because, see, in India we have legislature. In legislature we have two houses, Lok Sabha and Rajya Sabha, and ministers who are exactly executives, are part of this legislature. That means in our country, most of the ministers or all the ministers are either part of Lok Sabha or Rajya Sabha. These ministers plays a vital role in lawmaking process too. So in India, in case of India, the divergence between the powers of the executive and legislature cannot be clearly defined. So in case of India, the powers of legislature and executive cannot be diversified. But in cases of United States of America, in case of United States of America, lawmaking, law implementation, and law adjudication, all these functions, all three functions are performed by different organs. So in cases of where the presidential form of government is there, where there is a presidential form of government, there is clear-cut difference between law making, law implementation and law adjudication. Where in the countries where there is presidential form of government, in the country where there is presidential form of government, there is a clear difference between law making, law implementation and law adjudication. See, I will repeat the concept once again, dear friends. Doctrine of separation of power means law making, law implementation and law adjudication should rest with three different organs of the government. That is, law making should be done by legislature, law implementation should be done by executives, and law adjudication or dispute settlement should be done by judiciary. But in case of India, it is not possible that all these functions are performed by different organs, because in our country, ministers which are executives are part of legislature. That means ministers plays a vital role in lawmaking process. So it is not possible to diversify the powers of legislature and executive. Number one. But in case of presidential form of government, like in case of United States of America, law making, law implementation and law adjudication is done by three different organs of the government. So there is a clear-cut mandate. And remember who gave it? The philosophy of the doctrine of separation of power, and it was given by the French philosopher Montesquieu. Now we'll move on to the next. After erasing this, we'll move on to the next topic. Just wait. The next topic is doctrine of checks and balances. See, the concept is very much easy. See, in doctrine of separation of powers, we said that all the functions of an organs of government should be performed by different organs of the state. That is, legislature should involve in law making, executive should be involved in law implementation, and the judiciary should be involved in law adjudication. But in case of doctrine of checks and balances, each organs of the government, each organs is that, for example, legislature will always keep an eye on the functions performed by executives and judiciary. That means each organs of the government keeps an eye on the other form of government. Like, let us take the example of United States of America. Like in the case of United States of America, all treaties and appointments made by the President of US has to rectified by the legislature or the Senate of United States of America. Let us make it more clearer. If the President of United States US signs a treaty, then the treaty has to be approved by their Senate. That means without the approval of the Senate, the treaty won't be coming into the existence. That means in this case, the legislature or the Senate has higher power compared to the executive, that is the US President. I hope you got it. I'll repeat it once again. In doctrine of checks and balances, we need to prove that one organ of the government keeps an eye on the other organ of government by balancing its power. For example, in United States of America, President is executive. President is executive. This much is clear? See, if President signs any treaty, the treaty has to be accepted or rectified by Senate, that is legislature. See, in this case, the legislature of United States of America has more power over the executive. That means the legislature keeps an eye on the executives of United States of America. This is the first point. Now, the second point is how the legislature has more power over judiciary as well. See, if the judge of Supreme Court or the justice of Supreme Court of United States has to be removed, where will be the resolution will be presented, where the first step will be taken, the resolution has to be presented before the US Senate. That is, if judge of Supreme Court has to be removed, if the judge of the Supreme Court has to be removed, resolution has to be presented in Senate. That means in this case we are trying to prove the Senate is keeping a check on judiciary as well as. In the first case, we tried to prove the legislature is keeping a check on executive. In the second case, we are trying to prove the Senate or the legislature is keeping a check on judiciary as well. So we are clear with two cases where the legislature is powerful and keeping a check on executive and judiciary. Now we will move on to the third case, executive's check on legislature. See, we have to treat each organ equal and keeping an eye on other check. Now, any bill that is passed by US legislature has to be rectified by the president. Suppose legislature of US passes a bill. If legislature of US passes a bill, this bill has to be rectified. This bill has to be rectified by president, and president is definitely part of executive. That means if the legislature passes a bill and the bill is not rectified by the president, the bill won't turn into an act. That means to make a bill or to make a law, the verdict of the president or the final assent of the president is very much imperative. So in this case, we are trying to prove the president is powerful and keeping a check on the legislature, that is US Senate. Now, we need to prove that judiciary is equally powerful as executive and legislature. Suppose, let us take a same example. See, suppose the legislature of US passes a bill and the bill is even given assent by the president. In these cases, the bill has been given assent by the president and the bill is passed by the honorable president. Now what? And judiciary finds it that the bill or the act made, once the bill is passed, it becomes a law or an act. The act made is not in accordance with the Constitution of US. The judiciary has to declare the act as null and void. The judiciary act has right to declare the act as null and void, or say the act won't be valid anymore. We have analysis 3 cases. See, the first case was in doctrine of checks and balances. We needed to prove that each organ of state keeps an eye on other organs of the state. In case of United States of America, we took an example. All treaties signed by United States America's president or all appointments made by the United States of America's president has to be rectified by legislature, that is Senate. Number 1, in this case we tried to prove the legislature of United States of America is keeping a check on the executive, that is president. In the second case, we tried to prove that in order to remove a judge of Supreme Court, the resolution has to be presented, in the Senate, that is legislature. That means the legislature is keeping a check on judiciary. In the third case, we tried to prove the executive's check on legislature. A bill passed in legislature has to be given assent by the President of United States of America. If that is, the President is keeping a check on the legislature. Judicial control over executive and legislature. It is very much simple. A bill passed by legislature, given assent by president, and judiciary finds it that bill is not in accordance with the constitution, the judiciary has right to declare the act as null and void. That means the judiciary can declare act as an illegal act. In this two topics, we have learned that doctrine of separation of power and doctrine of checks and balances. Doctrine of separation of power was clearly saying that each organ of the states will perform different functions. That is, judiciary will have its own functions, executive will have its own functions, and legislature will have its own functions. But in doctrine of checks and balances, we were saying that executive and judiciary will be keeping an eye on the functions of other forms of the state to balance its power and to keep a check. This is all for the today's class, that is doctrine of checks and balances and doctrine of separation of powers.